And joining us now on the debate for the full hour, in New York City, Ezekiel Edwards, staff attorney at the Criminal Law Reform Project at the ACLU. That, of course, is the American Civil Liberties Union. In London, Ontario, Christopher Sharon, professor of law at the University of Western Ontario. And with me here in studio, Tara Burke, professor of psychology at Ryerson University. Ricardo G. Federico, criminal lawyer based in Toronto. And John Way, professor of pathology and molecular medicine at McMaster University. So we're going to talk about how the criminal justice system has evolved over the past 2 decades or so as it pertains to what is widely described as the gold standard of evidence, DNA. But before we get there, John, what is DNA?
DNA is a substance that's found in all of our cells, and it codes for all the information that's necessary to make a human being. We have about 80 trillion cells in our body, and all of those cells, most of those cells have DNA in it, and the DNA is the same in all of those cells.
Chris, let me ask you this. How does DNA work in the criminal case? How does it provide evidence for a criminal case?
Well, most usually what happens is that the authorities investigating a crime find some sort of biological material at the crime scene. They then attempt to get a DNA profile from that biological material and then see if it matches up with a particular suspect, or sometimes they put it into the DNA data bank and see if they can get what's called a cold hit, basically a hit with, or a match with somebody who's not previously a suspect in the case.
And we, of course, have a DNA data bank here in Canada and also in the U.S. John, you're the scientist amongst us. It's often referred to DNA as a genetic fingerprint. Is that an accurate description?
It's actually better than a fingerprint. It's very unique, and as opposed to fingerprints, DNA, you can link it back to a particular cell type, whereas as opposed to a fingerprint, a fingerprint you can leave on a table and you don't know when it was put there. But for biological material, you can match back to a particular cell type or material that you find at a crime scene. So it has more information.
More information than a fingerprint. Yeah. We've been using this in our court systems in North America since late 80s. And when it first came out, it was hailed. It was a breakthrough. It was going to change the way our criminal justice system would work forever. Has it lived up to that standard, Federico?
Well, I think it's definitely revolutionized the manner in which criminal investigations are conducted, the manner in which criminal trials are conducted. Has it lived up to the standard? We have evidence now that there are many blunders globally where mistakes have happened. And does it deserve the golden standard? Perhaps not. That's my position on it. We have people that have been falsely accused and falsely convicted because of DNA.
We're going to talk more about wrongful convictions, but Ezekiel, I want you to weigh in. How do you see DNA? Is it as good as it was sold?
Well, I think DNA has clearly had a huge impact, as Federico said, on the criminal justice system. It's on the front end, the police now, the way that they conduct eyewitness ID procedures, the way that they are trying to improve their interrogation techniques to prevent against misidentification and false confession, and then the way courts are starting to assess the evidence. It's certainly had an impact on the question of accuracy.
Tara, from your perspective, pardon me, how do you see DNA as it pertains to our justice system?
Well, I think, as Ezekiel was saying, one of the advantages of DNA is that it's, for those of us interested in wrongful convictions and the factors leading to it, it's brought a lot of attention to the issue. One of the things that we don't typically have, whether in real life or research, is absolute truth. So we can't typically know whether someone really was or wasn't guilty, despite what a jury decides. So to some extent, certainly not 100%, but to some extent, this gives us pretty good evidence that someone was or was not guilty, which is a pretty nice starting place that we didn't have before.
So we can agree it's not perfect, but it might be the best that we have, John?
Correct.
Tara, you agree? You think it's pretty good?
I think it's pretty good. Again, from a research perspective and looking at the wrongful conviction cases, it's compelling. It's compelling to a jury, and maybe more important, it is compelling to Crown prosecutors, to Crown attorneys, that somebody really might not be guilty despite their being absolutely positive that somebody was guilty in the first place.
Chris, I want to ask you, when we talk about DNA, I think to most lay people, including myself as a journalist that's often in courtrooms where we hear about DNA evidence, people seem to think of it as sort of infallible, that it's objective. Is it objective?
No, nothing is entirely objective. There is some interpretation involved, and John would be able to speak to this much better than I could, but my understanding is there's some interpretation involved in the analysis of DNA evidence. But also, you can't forget that there are human beings dealing with the evidence, so there's always the possibility or the risks of contamination, of simple human error, of misunderstandings on the part of either the scientist or probably more likely the jury or the court or the judge in question won't necessarily understand exactly what is being said, the significance of what is being said. So even if the science itself is not only good, sort of generally speaking, but was applied properly in the particular case, it won't necessarily be understood as it should be properly understood by a jury or a judge or anyone else in the system.
You know, a few of you have brought up the words wrongful convictions, and I want to talk about that in a minute. But first I want to talk about rightful convictions. Has DNA allowed us to put the right bad guys? Has it helped us being able to put bad guys or bad gals behind bars, Ezekiel?
Yeah, DNA has helped prosecutors. There have been a number of cases, wrongful convictions, where they're actually then able to match the DNA to the actual perpetrator. So it has both freed people and then put culprits behind bars. I think when we talk about DNA and how it's revolutionized the system, just in terms of the innocence question for now, I think we have to be cognizant that only 5 to 10%, at least in the United States, of cases of criminal cases involve biological evidence. Most of the 269 people that have been exonerated through DNA in the United States, those were rapes and murders, which only make up 1 to 2% of felony convictions every year. So certainly within those small cachet of cases, DNA is critical both in finding the right person and exonerating the innocent person. But it's a small fraction of cases that go before the criminal justice system. So its impact on the system as a whole is far less large than on those small subset of cases.
Ricardo, you're in court often. What do you think of what Ezekiel's saying?
Well, it's certainly revolutionized the manner in which we conduct ourselves. I'd like to be mindful of the fact that scientists do make mistakes across the board. There's no question about that. It's what's a little bit disturbing is that we have mistakes that are happening. We have mistakes that are happening on an international basis. And we look at the data bank as an example, and we see that the gatekeepers to the world are the RCMP in this country. So once you're in the data bank, the concerns that I have are privacy. The concerns that I have are what happens to the DNA once it's in there. It exits the country. It goes to another country. What happens when it's in that country? Do you have another police force looking at it? We have a lot of very few examples of how mistakes are made once it exits the country. The data bank, in terms of policing the data bank, it's my view that the police should not be the gatekeepers to letting the DNA go to another country.
John, what do you think of that? Should police be the gatekeepers?
I don't think the police are really the gatekeepers. There is an organization that runs the DNA data bank and is in charge of disseminating information. If a request is made to compare a profile to the data bank, they will compare it. If there's no match, they'll say there's no match. If there is a match, they'll say there is a match. So they're not handing DNA around. They're comparing unsolved case DNA profiles to profiles that are in the system. But yes, that is in control of a police organization. Or
let me ask you this. I'm a suspect in a case, and the police get the right legal things to come take my DNA, and they have it, and suddenly, you know, I'm exonerated. I'm not exonerated. I'm not even charged. What happens to my DNA? Does it stay in this bank?
It depends. If they have a warrant to, and Ricardo would know more about this, but if they have a warrant to collect your sample and it doesn't match to that case, that sample will be discarded. It has to be discarded. But if you're being pursued as a possible suspect and you don't know you're a possible suspect and there's no warrant issue, they can follow you around. You drop a Tim Hortons cup or a cigarette butt, they can collect that, take it to the lab, get your DNA profile, and put it in an investigative database. And even if you're not, even if that doesn't match up to the case, that stays in the investigative database, and that can be in there for a long time. That's not covered by the actual legislation.
Chris, do you have concerns about how DNA is taken and kept in this country?
I mean, there's always concerns about whether we've, you know, realized the optimal system here. I don't have too many concerns. I think we've adopted a pretty good system. There's always the possibility of abuse. There's always the possibility of error. And John's correct that you can, in some instances, have a person's genetic profile contained in a database for an extended period of time. But that in and of itself doesn't trouble me unless it would be accessible to government authorities, to private individuals or whatever. And to my knowledge anyway, it's not readily accessible.
Tara, let me ask you, DNA is now used, well, in a lot of court cases. It's not as many as maybe people suspect. But when we talk about it, we've already talked a little bit about wrongful convictions. Let me ask you, how has DNA made law enforcers more accountable, in your opinion?
Well, I mean, I think as we were discussing before, it's brought so much attention to it. Nobody wants to be overturned on appeal. Nobody wants to, police don't want to be involved in a wrongful conviction. So it's yet another piece of evidence that we can use, that they can use to try to decide that someone was or was not guilty. So I think it can help. It can help focus an investigation. At the same time, one has to be concerned from a psychological point of view. One worries about things like tunnel vision. Does the fact that DNA was found that matches mean that that person becomes the one and only suspect, and all resources go to proving that that person was in fact guilty, as opposed to using it as evidence, but not the one and only piece of evidence? So I think it certainly helped to focus the investigation in some cases.
You're in court every day. Maybe not every day, Ricardo, but you're in court a lot. When you have a case where there's DNA involved, does that change? What goes through your mind when you hear DNA may be involved? Does it change anything for you?
It changes a lot. It changes how you govern yourself in the preparation. You definitely need an expert like Dr. Way to help you out in understanding what you need in terms of disclosure, in terms of what you need in terms of applying the principles that you have, and scientifically that is. And it does put a fist, I say, across the board on the scales of justice when a jury or somebody hears the circumstantial evidence and hears that you have DNA evidence.
What about for you as a lawyer?
It's a lot more preparation.
How so?
Well, you have a scientific issue that you must deal with. You also have an issue as to how this fits into the entire picture and what it really means in the context of the case.
Ezekiel, let me ask you that. With the ACLU, I mean, when you hear that DNA is involved in a certain case that you're looking into or looking at, does that change things for you radically?
Well, it certainly, DNA certainly changes the complexion of a specific case. In the United States, at least, though, we have tremendous problems in our criminal justice system that, unfortunately, DNA can do nothing about. And the innocence movement, as laudatory as it is, cannot do anything about. We have 2.3 million people in prison in the United States. We have 5% of the world's population, but 25% of its prisoners. 1 in every 31 adults is behind bars. So that's really not a question of strictly accuracy. Did someone do it? Did someone not do it? It's really a broader question of fairness. Who are we prosecuting? Why are we prosecuting them? How long are we sentencing them for, putting them in jail for? And the conditions under which they're being kept in jail. These are huge issues in the criminal justice system. The amount of money we spend. Since 1970, we have a 700% increase in our prison population. States spent $44 billion in 2007 imprisoning people. And so while DNA is very important for the question of accuracy in rape and murder cases, it's really not going to have an impact on this kind of addiction to incarceration that's been happening in the United States really since the start of the drug war in the 1970s.
Chris, what about the idea of for suspects? When they hear in an interrogation or some sort of questioning that there may be DNA evidence involved, in your assessment, what kind of role does that play for the suspect?
Well, it depends on the context, but if you're talking about an interrogation where the police are trying to obtain a confession from an individual, if the person hears that there is DNA evidence that inculpates them, in many instances, I think that can have quite a dramatic effect on the suspect. It can, if he's guilty, it can make him sort of realize that the game is up. He might as well confess, which is a good thing. Unfortunately, if he's innocent, it can also have a similar impact. Because the suspect may feel that there is no point in continuing to deny guilt, that he is going to be convicted because of this incredibly powerful DNA evidence. So maybe there is some benefit in falsely admitting guilt because that might in some way minimize his punishment, obtain other sorts of leniency from the authorities. So it can have a powerful impact on both the guilty and the innocent, and not always a positive one.
I want to talk a little bit more about false confessions, and I want to bring up a case, maybe you're familiar with it. It's a case in the United States, a 14-year-old boy named Michael Crow. He's a prime example of a false confession. He was convicted of murdering his 12-year-old sister back in 1998, a crime he did not ultimately commit. Let's first take a look at a bit of the interrogation of Michael.
It's like I have this overwhelming feeling that I killed her, but
okay, let's hear. Let me hear about. Let me hear about.
I don't know why I feel that way.
Let me hear about it.
All I know is for some reason I can tell I killed her. I don't remember what I did. I'm trying to tell you. You say I did it. Got a knife. Went to a room. And I stabbed her.
Tara, you're shaking your head. It's a remarkable case. 4 years after that, a DNA test proved that a drifter was actually the guilty party, and it led to the exoneration of Michael and his two friends. But in many cases, there isn't DNA evidence available. So when you see that, Tara, what goes through your mind? Has DNA changed how we do interrogations in our justice system?
Well, I mean, in the initial interview for Michael Crow, I don't think they, at least initially, said there was DNA at the time. I mean, I'm shaking my head because there's so much wrong with what happened in that interrogation. I think, as we were talking about before, it may be the case that it might be suggested to the suspect that they have DNA, or in this case, that they just have absolute proof that he did it, even when he didn't, and that becomes part of the self-narrative for the suspect, if they're innocent. I mean, certainly if they really did it, as he was saying, that means the jig is up. They might as well confess. But for someone who's innocent, if they hear there's DNA evidence, there's been numerous cases where the person starts to think, well, geez, if there's evidence, maybe I just don't remember. As Michael Crow said, we've had some cases in Canada that are very similar, where the person just starts to change their memory of the event. People are telling them, absolutely, there is this irrefutable evidence that you did it. And they start to think, okay, well, now I maybe better start to imagine how that's possible. And once they start to imagine maybe that's possible, then that can actually become their memory of the event.
But because of DNA, do we see less of this sort of thing, this sort of pressure confession type stuff, false confessions?
Well, as was stated before, the problem, I guess the problem is that DNA is really only available in a very small number of cases, relatively speaking. So if we're talking 10% of the cases, there's still 90% of the cases out there where there isn't DNA evidence, so we're relying on other factors to try to get that confession.
Ricardo, what goes through your mind when you watch that Michael Crow interrogation and
well, it's awful to see what happened. It's awful to see how the police have approached him. And it's awful to hear that he said what he said, and it's just you see it quite often.
And what's your sense of, in terms of confessions and false confessions? How has DNA played into all of that?
Well, if for example, if you're told that there's DNA at the crime scene and it's consistent with yours, it's going to have a profound impact on what the individual will say, and I think it's awful to hear, and it's difficult to sometimes refute what the police are saying, and you hear what I hear in the courts, and what DNA means these days, do not acquit. As a joke, they say that, and that's not nice to hear, because some of my colleagues were walking in the halls of the courts, and DNA means do not acquit, and that gives you kind of a sense of what is happening out there in terms of the profound impact it's had on whether or not it's a confession, whether or not you're a lawyer, whether or not you're a judge or a juror listening to a case across the board.
What do you tell your clients in cases where DNA has been involved? What do you say to them?
You say, we have to challenge the science. Is it really reliable? Scientists make mistakes, and these are the mistakes. I collect DNA mistakes as a hobby.
A couple years ago, Forensic Science International published a report by scientists in Israel. The scientists claim they can fabricate DNA. I mean, this is sort of sci-fi kind of stuff, but they said they could do that. John, do you think that DNA can be fabricated quite easily? And if so, what does that mean?
Certainly. Part of the test is you actually are making copies of the DNA. So all they've done is they've taken the test that's used to analyze DNA. Usually take DNA from a blood stain, and you make copies of it and you analyze the copies. Well, all they did was say, if I want to frame somebody, if I know what their profile is, I can go to my library of people that I've analyzed, and I can pick different elements that will match up and create that profile of that person that I want to frame. So it's very easy to do. Very
easy. So we'll hear more and more cases of DNA being fabricated as time goes on?
I suspect not. That criminals don't have their own DNA labs.
Homemaker's kit of DNA.
Most of them aren't geneticists, and yes.
Chris, what do you make of it being a risky proposition that DNA, you know, we're not making it at home, but guys like John might be able to make it in the lab?
Well, I don't have any concern that John's about to do that. But,
we won't tell.
No, I think that's right. I mean, you know, you hear these stories that you can fabricate DNA and so forth. And there's always been the possibility of the authorities, for example, planting evidence. You know, just think, at least allegedly, back to the OJ case. Whether or not that's true, I'll refrain from commenting. But anyway, so I don't think that's a new development, and I don't think it's going to be a particularly problematic development. People just don't have access to the technology, and they wouldn't know how to do it even if they did. Wouldn't know how to use the technology even if they did have access to it.
Ezekiel, from your position, does that still, if it's not as easy to do, but doesn't it still undermine the credibility further of DNA?
I wouldn't say it does. I mean, the fact that you can replicate it and copy someone's actual DNA and plant it, I don't think that's going to happen a lot. And it doesn't mean that when you find a profile at the scene that it's not really the gold standard if procedures are followed correctly to identify the true perpetrator. And when I was listening to that confession, it should be noted that what DNA has done, as I said at the outset, has started to change the way that police kind of do certain things. For instance, now interrogations are recorded, and ideally they should be recorded from the very start of police contact to the very end. That's not necessarily going to prevent all false confessions, but if the police know that they're being watched and videotaped, some of the tactics that they use, they're going to refrain from. With eyewitness identification, there are now a set of best practices that 30 years of robust social science have shown minimize mistaken ID, particularly double-blind procedures where the administrator doesn't know who the suspect is or who the perpetrator may be, giving warnings to witnesses that the perpetrator may not be present. A lot of police departments are starting to adopt these procedures. So again, from a kind of guilt-innocence standpoint, DNA has started to a swell of change in how investigations and police procedures are performed.
Tara, you're nodding your head. Psychologically, is it a game changer for police?
I think, as Ezekiel was saying, it becomes part of best practices in terms of, as you're saying, for the eyewitness evidence, that it becomes, again, as any type of evidence, somebody wants to ensure that that's collected correctly. You know, this is in the context of then how a suspect is interviewed, or a witness is interviewed, a suspect is interrogated, or how an eyewitness is asked about the case, and so on. So from an Innocence Project perspective, again, it's a game changer in the sense of it gives us a little bit more ammunition, and it is another hopefully solid piece of evidence, but again, one that unfortunately juries have ideas about DNA. They think that most cases involve DNA, and they assume they're more likely to assume it's infallible. There's something now that in research jargon is called the CSI effect, where juries assume that there's always DNA, that they always use luminol, that all of these things can be solved in an hour. Of course, that's not real life.
Let me ask you about that, Ricardo, because Tara makes the point that lay people, juries, you know, when they hear about DNA evidence, they might give it a different sort of weight in terms of evidence than others. How do you sort of guard against that when you're in court?
That's a good question. It's my view that the jury should hear about the mistakes and the flaws associated with DNA, and there are many out there now that you can point to, where even the people who are innocent have been convicted because of DNA. People who are and as I said earlier, in other countries efforts have been made to extradite them because of DNA. The jury should hear about that. The jury should understand that mistakes do happen, that it's not perfect, and that it's not what they may think it is, or what CSI effect is telling us about. Or they should hear about the mistakes. They should hear about what reality is and where this is all leading. That's my view of what the jury should be hearing.
Chris, they might hear it.
I would just
go ahead, Ezekiel.
Well, I just wanted to add that, you know, in terms of what the jury should be hearing about, I think they should also be hearing about, for instance, the fallibility of eyewitness identification.
Right.
There's 35 years of copious social science research that shows factors that can increase error. And many times jurors are not given proper instructions, at least in the United States, about what may or may not have caused this eyewitness to be wrong. They often, increasingly, they're hearing from experts, but there are still courts that won't allow social scientists to testify about the research on eyewitness ID. So certainly if you're going to be telling jurors about DNA not being 100% perfect, you should absolutely be telling them about what causes a false confession, how eyewitnesses get it wrong, because these are the factors that lead to wrongful conviction.
Okay, I want to bring up another quote here. This one comes from Michael Lynch from Cornell University. Take a look at this. Easily forgotten in this equation of DNA with science and truth is that until recently, latent print comparison, fingerprinting, was deemed to be absolutely certain, unassailable, and error-free source of scientific evidence. Though still pushed by FBI spokesperson, fingerprint analysis is now criticized as less scientific and possibly less reliable than DNA fingerprinting. Okay, who wants to jump in here? John, is that true? I mean, what are the pitfalls if we become too dependent on DNA, given that scientific evidence has changed historically?
Well, I think you can look at DNA and latent fingerprints in the same context. You can have weak fingerprint evidence, that is, you have a smudged fingerprint or you only have a partial fingerprint, and that's weak evidence. And depending on where you are in the world, they may count that evidence and say it's a fingerprint match. In other places, they may say this is not enough to draw any conclusions from. Same thing with DNA. You can have a very weak DNA match, you can have a very strong DNA match. So I think you have to look at the evidence in its totality and see whether you've got how many points of comparison you have and how discriminating it actually is.
Ricardo?
When it comes to fingerprints, historically Canada did not have a test in the courts until recently for novel scientific evidence. So when fingerprints became originally part of the science scene, it's my view that they didn't pass it wasn't litigated, the threshold for novel scientific evidence. And maybe throughout the years, bad science made it into the courts because we as lawyers didn't push the envelope or didn't ask scientifically, what is it, why should this be admitted, why should it come in to be a part of the evidence. And now I think DNA evidence has changed the judicial landscape, will continue to change the judicial landscape, and we'll see it's pushed the envelope to the point where, yes, we now have a test for novel scientific evidence, not because of DNA, it happened before DNA, but you look at it from a novel scientific point of view, and you try to ask the scientist the relevant question when it comes to novel scientific evidence before it becomes evidence, not after it becomes admitted as evidence.
Chris, is it going to do, as we move forward, is DNA going to do what Ricardo says it is? It's going to evolve and change our justice system further?
I'm sure it will, but I think all this raises the important issue of the systemic impacts of the creation of DNA evidence. And there are many different systemic impacts, but just going back to fingerprinting or other more traditional forensic sciences, there is a call now, not exclusively, but largely because of the of DNA evidence, a call for more traditional forensic sciences like fingerprinting, like tool mark analysis, and all those sorts of things, to adopt more rigorously scientific procedures, methodologies to be validated. I mean, an issue with fingerprinting is that fingerprint examiners are instructed quite vociferously by the organization that you testify that something is a match or it's not a match. There is no in between. There's no sort of it's 90% sure it's a match or whatever. That's not how DNA evidence is presented in court. The DNA examiner will go in and say there appears to be a match, and the probability of this being a random occurrence is 1 in a million, 1 in a billion, whatever it happens to be. We don't get that sort of statistical analysis that, of course, helps inform the court as to the meaning of the evidence. We don't get that sort of statistical analysis traditionally in many other forensic disciplines. So one systemic impact of DNA evidence is it going to push these old traditional disciplines into adopting a more rigorously scientific approach to not only the analysis of the sample, but the description of the results and the explanation of the results in court.
Ezekiel?
Yeah, I would agree with that. I mean, I think there's a number of wrongful convictions that have been caused by what you would refer to as junk science, a bullet lead analysis, sometimes fingerprints, bite marks. Certainly in the arson field, there's been a lot of attention to wrongful convictions caused by alleged experts identifying something as arson when it wasn't. So I think DNA and certainly the Innocence Project in New York is pushing aggressively for much closer oversight of all of these, forensic disciplines that have really passed without great oversight in court for years and put people behind bars.
Does DNA help in the appeals process? If you have DNA, Ricardo, does that mean you kind of get to jump the queue? Not at all?
Not at all.
Never happens, because when we hear about wrongful convictions, DNA usually plays a critical role. In reopening cases, I mean, when they examine that, they don't say, we got DNA here. Maybe we should give it a second look faster than we would other kinds of evidence coming forward?
I don't think the cases are given a faster look because of if DNA is missing or whatever is involved in the case. I don't think they jump the queue because of DNA.
Last August, New Scientist magazine polled 13 DNA analysts, and all but 2 of them, so all but 2 makes 11, agreed that the courts put too much emphasis on DNA nowadays, and especially in jury cases. I mean, if the scientists themselves are saying that, John, I'm going to ask you to speak for all scientists apparently. I mean, why aren't we changing? Why aren't we listening to you scientists?
We don't really have much control when we're in court how much emphasis the court puts on it. I know the lawyers and the prosecutors put an enormous amount of emphasis on it, and sometimes that's all you're told you're the main witness, and your evidence is the main evidence, and you get the full attention of the court. So it has given a huge amount of impact, and sometimes you look at it and it really is just one piece. Sometimes it's the whole case, but in most cases it's just one piece.
If I could just chime in here, if you don't mind. I mean, this raises another systemic issue, which is not a good one. I mean, the push to sort of make more traditional forensic sciences more rigorous is a positive development. But it comes, or it can come, with a cost. If you present this more rigorously scientific evidence in court, you provide statistical analysis. That places a great strain on the system, on all the actors in the system, including the jury, but not just them, the defense counsel, the Crown, the judge, to properly interpret and understand that evidence. And there's a lot of research out there that shows that people who are not trained, like John is, who just find it very difficult to truly understand the meaning of a statistic such as the possibility of a random match is 1 in a million. What does that mean? It certainly doesn't mean that the chances of guilt are 1,000,000 to 1, but some people might interpret it to mean that. So there are other systemic problems that DNA is going to cause, and real challenges for the system as a result.
Ezekiel, I mean, how do you explain this? If we're not going to get it, I mean, how do we get better at explaining to people what to make when they hear of the kind of DNA evidence that's presented?
Well, I certainly agree that it's difficult for judges, sometimes even lawyers, and for jurors as lay people to understand forensic science, even understand social science. And that's a concern in, for instance, the eyewitness field, that if you're giving juries instructions and bringing in experts, how are they going to understand adequately, and how are they going to assess probabilistic, social science, statistic-heavy evidence? I think the answer is not, and not that this was suggested, but to take that out of the courtroom. I think the answer is to simplify it to the extent possible, write clear instructions, tailor expert testimony to be as accessible as possible, so that jurors, make analogies, so that jurors have some sense and are educated about all of these different factors that can increase or decrease the possibility of guilt or innocence.
Ricardo, is that good advice for lawyers to help jurors understand DNA, to use the things that Ezekiel is saying?
Yes, I think so.
Do you do that?
I haven't done it lately, but I think that the jurors must hear the truth about DNA, and that scientists, again, repeating myself, is that scientists make mistakes and there are problems. There's no doubt it's a one component of the trial. It's a circumstantial evidence, but has a profound impact on the jurors, and the jurors should hear the truth about DNA.
I want to ask all of you, we're just wrapping up here, but we've discussed how DNA has convicted the guilty, exonerated the innocent, but it's also, really provided a window, if you will, to the engine room of the criminal justice system. So what has DNA taught us about the process of how law enforcement works? Why don't you start, John?
Oh, I think it's revealed a lot of flaws in the system. Whenever you critically look at a system, and I think DNA has caused us to step back and critically look at how evidence is collected, how it's handled in the lab, how it moves its way through the legal system, and how it's interpreted by jurors. So at all stages there, I think it's revealed flaws in the system and ways and things that we can certainly improve upon.
Tara?
Yeah, I would agree, and I would say as well that it also suggests, as I think much of the research would say, that it's probably the tip of the iceberg in terms of wrongful convictions. Again, might be the best thing that we have right now. It's not the only thing, but it suggests that there's a lot more cases out there that should probably be looked at.
Chris, what do you think? What has DNA testing taught us about our criminal justice system and the processes for our law enforcers?
Well, one important thing that it's accomplished is that it's provided researchers with a database that they can examine when they're trying to figure out where the system goes wrong when it does go wrong. So once you've got this dispositive proof that somebody is factually innocent yet was convicted, you can look back at that case, and of course if you compile a whole bunch of those cases, you can look back at all those cases and try and see, is there some commonality? How did they get convicted in the first place? So Ezekiel's been mentioning eyewitness identification evidence. Certainly the frailty of that evidence has been highlighted as a result of all this DNA exonerations, but it also has informed us about the weaknesses of some forensic sciences, the weaknesses of some defense work, some prosecution work, tunnel vision. It has raised all these issues about the fallibility of our justice system and all the ways in which it can go wrong, and therefore has allowed us to start, I hope anyway, move forward and say, well, all right, this doesn't seem to work, so let's try something different, and hopefully that will produce a more accurate result.
Ezekiel, has DNA taught us anything good about our criminal justice system?
Well, I would echo all the comments in terms of what it's done in terms of accuracy, and obviously I think we're all concerned in a specific trial whether or not this person was rightly or wrongfully convicted in terms of guilt innocence. But I do want to go back to the fact that what it can't reveal is other travesties that actually have a much greater impact on people, at least in the American criminal justice system. Just for instance, we are the only country in the world that incarcerates juveniles to life without the possibility of parole. We have 500,000 people in prison for nonviolent drug offenses. These are things that DNA can't do anything about. The length of sentences. A man in Louisiana a couple months ago was convicted of selling $25 worth of marijuana, and he got 30 years in prison. I mean, these are the things that aren't about accuracy. They're not about guilt or innocence, but they are about fairness. And so while I think the innocence movement is critical, and the innocence projects are doing amazing work getting innocent people out of jail, the truth is there are many other travesties in the American criminal justice system that DNA can't really touch. And my only concern with the innocence movement is that it distracts us sometimes necessarily, but oftentimes in a way that's troublesome from many other questions about who we're prosecuting, how long, and the size of our prison population.
Ricardo, is it a distraction?
Well, it could be a distraction. I think it's showing, it's amplified the problems in the system, and it's going to continue to do that, and it's humbling, and the system is not perfect in Canada. And there are many problems that still exist today when it comes to other forensic components of trials that I believe DNA is amplified and showing us that mistakes happen. And it's also, it's refreshing to see that the system is open-minded, whether they like it or not, to the system as being flawed.
Well, clearly from our conversation, maybe the gold standard isn't appropriate. Maybe a bronze standard has been tarnished a little bit. DNA. Thanks, everybody.
Thank you.
Chris Sharon is a professor of law at the University of Western Ontario. Ezekiel Edwards, staff attorney, criminal law reform project with the American Civil Liberties Union. And here in studio, Tara Burke, professor of psychology at Ryerson University, and John Way, professor of pathology and molecular medicine at McMaster University. And on my right-hand side, Ricardo Federico, criminal lawyer based here in Toronto. Thank you.
Thank you.
Thanks.